Good morning, everyone, and welcome to another edition of our Justice and Peace's guest speaker series, as we've been talking to lawyer and paralegal bencher candidates about the upcoming election. As always, the views and opinions are of the candidates alone. They don't reflect me, Justice and Peace's, Trials College, or any other education institution or organization that I'm affiliated with. Continuing on this morning, we have Russell joining us. So, Russell, first of all, thanks for taking the time to speak with me, and perhaps maybe you can tell us a little bit more about yourself.
Well, it's my pleasure to be with you today, JP. I first want to give my gratitude to you for inviting me on to your program. That is very kind. And also express my gratitude to your audience and your listeners. Thank you for tuning in to the series John Paul has produced. It's a really helpful tool to understand the issues that we're looking at for the 2023 Law Society elections. So who am I? Why am I running? Well, I've been in the game for 25 years, called to the bar in 1998. This is a chance for me to serve our profession, to give back to our profession. It's a chance for me to show some leadership. This has been an exciting new challenge for me and my team. And this also, John Paul, enables us to showcase our core values that we operate our law firm from. That's respect, teamwork, service, and leadership. And those values inform the way we operate our firm, and hopefully will inform the way I make decisions as an elected bencher.
Yeah, so you touched on it a little bit there, but why are you running here after 25 years of practice? What's motivating you this time to put your name forward?
Well, I'm really excited about a number of things. First of all, I think we have a chance here to improve access to our justice system. And we can do that in a number of ways. One of the silver linings, JP, of the pandemic was the pivot of the justice system from a paper-based system, which we had for over 200 years, to digital. So that includes filing your documents online. It includes what we would call a Zoom divorce. So we're doing these court hearings by Zoom. So what that does, pre-pandemic, and now we're going back, the judges want lawyers to go back to in-person hearings. So you show up for your 9:30 hearing and you're there for 6 hours. You might not get heard until the afternoon. You got to travel, you got to find parking, you're buying gas, bad for the environment. So your 1 hour hearing becomes a 6-hour day. During the pandemic, the 1 hour hearing would be a 1 hour hearing, or maybe 45 minutes. So that freed up lawyers' time to help other clients who needed service as well. In addition, if we think about our clients, JP, this stretches their legal budget, right? So if we go to 1 or 2 hearings, it's going to be $3,000, $4,000 if I'm there all day. If it's only an hour or 45 minutes, that means they can get maybe 5, 6, 7 hearings out of their budget, and they don't have to go self-represented. So that improves their ability to access the system and not have and to have a lawyer help them through it. Perhaps most importantly, if you think about victims of domestic violence, they go to family court, they have to be 6 to 10 feet from the person who beat them up or abused them for several years. And it's a very traumatic experience. And some people use the court process to continue to abuse their spouses by dragging out the case and so forth. With remote hearings, they could do it from the safety of privacy of their own home. They can have support networks. They can have a care dog or a pet with them. And it makes it a lot more private and a lot more safe for those individuals. So that's just one issue that I'm excited about. Another one is promoting collaborative practice and mediation. So if you think about our court system and how it's jammed up, and we're all hearing about delays and expense, and judges are overworked and people are going self-represented. I think we could do a much better job at focusing on keeping these matters out of the court system. Collaborative lawyers agree not to go to court. Mediation, there's other alternative ways to settle cases outside the court system. So the question is, how do we do that? Well, as a bencher, we guide policy at the Law Society. So we can educate, we can do CPD programs, we can encourage law schools to start educating law students about collaborative practice and how this could be a better way than going to court. So that's an immediate change we can make in May once the election is made or decided. The second thing we could do is we can, through the Law Society's power and influence, we can get the Ontario government to start promoting collaborative practice and mediation. So if you just think a few years back, we had the Good Things Grow in Ontario, right? Ontario government's promoting farmers and produce. We had Tourism Ontario, recently promoted by the Ontario government. There's no reason why the Ontario government can't promote collaborative practice and mediation and make this the new norm for people who are going through the court system. They don't have to go to court. And the benefit of that is it's going to alleviate the strain on the court system. We're going to get all these cases out that are backlogging the system, and it's going to settle. So the money the government spends on promoting collaborative practice is going to save it at the back end by not having to get more judges, build more courthouses, deal with unrepresented people, which creates a huge strain on the system. Other things that I'm really quite passionate about is, DEI, or the Law Society calls it EDI. I think diversity strengthens and enhances our profession. One of the first things we need to do is look in the mirror, see what our own practices are around this. I have a very diverse firm. When I interview articling students, we usually hire 2 students each year. 95% of them are racialized. And this is simply unfair. We need to do better at this. And there's lots of ways we can go about that. On that point, though, I've been talking to voters, and I've been receiving lots of messages about this particular issue. So I want to read a message from Gary Joseph, a senior family lawyer. He's given me permission to speak about this. And we're talking about the election, and he writes to me, "I cannot support the need for me to sign the acknowledgement that the LSO sought some time ago with respect to EDI. I believe in EDI, but it includes diversity of thought and ideas. I don't want the LSO telling me how to think and how to view the world." So when we look at, we're going to talk about the slates in a moment, but this is sort of the genesis or the firestorm that set off the division we're seeing in our profession. The Law Society was forcing this, and lawyers being the critical thinkers saying, "You're not going to tell me how to think." And now we've got this, this huge debate going on. I think diversity is a good thing. I want to promote it, but I recognize that, some people think the Law Society went too far. My freedom of thought, you can't impose on me how I'm going to think and how I'm going to do things. So this is sort of the debate that we're seeing in the profession right now. But those are some of the things I'm excited about. I can go on for an hour, but I don't want to take all your airtime.
Now, Russell, I guess besides being maybe the candidate that caused some scare for the married lawyer couples where they got the mail out from the family law firm and what's going on here, let's get into the slates and then the discussion there around election reform. And some people mentioned, for example, spending, right? Because there's nothing stopping anyone from doing exactly what you did. I mean, maybe I'm thinking back 2 years ago that was commonplace, right? Is that you'd reach the lawyers there, and part of some of the reason for slates and teams and coalitions, or however you want to call it, is that you can make donations to them, they can pool resources, they can spend a lot more. And some of the other independent or unaffiliated candidates that I've been talking with say, well, that puts us as kind of at a disadvantage because people are being encouraged to be voting collectively, and we can't kind of match spending or some of those issues there. So, I mean, what are your thoughts just generally, first of all, about having slates and coalitions? I mean, I think you can certainly go back well before I can about historically how bencher elections were conducted, and perhaps maybe share some thoughts about that to get started.
It's a great question. I've been practicing law for 25 years. And JP, I've never once met a lawyer who told me, I want to pay more fees and be subject to more regulations, right? That's like issue number one. Nobody likes that. So that's pay to play. So if you want to be a bencher, you're going to have to watch the Law Society's balance sheet. You have to moderate regulation. That's just what the profession wants right now, regardless of what slate you're part of. But that will get you in the door. we're talking about a juggernaut here. Law Society has over 500 people working for them, a budget of over $100 million. So this is quite a large entity, and lawyers are really tired of having their fees increase every year. So that needs to be addressed. The the slates represent certain segments of our profession, and we need to respect that, right? These slates exist because our colleagues feel a certain way about these issues. And, the media, I think, might be playing it up a little bit more than, creating a bit of an excitement in terms of the division. Ultimately, all benchers, in my view, want to have a law society that reflects our profession and that governs well. They don't agree on how to get to that result. And that's where we get these slates coming out. We have a marketplace of ideas. We have, lawyers are fairly talented, bright people, and they're good at arguments. So division and debate is normal, right? That represents a healthy democracy if we can have those discussions. Where it starts to become a bit of a slippery slope, JP, is when we get groupthink, right? I'm part of this slate, so elect me. And I guess the mindset behind that is we'll pool our resources and we'll get our message out there. And well, I'm not sure if that's healthy for the profession, right? We want people who are going to be independent, experience, exercise good judgment, and make decisions based on their values, not because I'm with these other 15 people who brought me to the dance. That doesn't make sense, right? That's not good for the profession. Sure, you have a respectful decorum and you have heated debates. That doesn't mean they're right or they're wrong. You're just playing around with the ideas. It's no different than arguing a contested motion in motions court. At the end of the day, we're still colleagues. We're still part of the profession. We still need to represent the profession in a proper way. So I think the slates, is good in the sense that these are segments of our profession that and interests, and they reflect their values. And I think that's a healthy thing. I chose not to be part of a slate. I think the Law Society and our profession needs a good representation of independent candidates who are going to listen to arguments, consider opposing point of views, not be to the behest of this group or this party or whatever we're calling them now, because they brought me to the dance. I want to think independently and make decisions that are right for the public and not decisions that are right for the profession. So I think there's some middle ground there for independents to step forward. And I think from what I'm hearing from the profession, through people emailing me and phoning me up, the profession wants some independent people in there who are going to, have some balance to their decision making. So I respect the slates. I think they represent some important interests in our profession, but I think independents have an important role to play too.
Now, Russell, one of the things that certainly could happen is, as you point out, is because both of these groups have strong support, is that members on both sides could be elected along with perhaps yourself and other unaffiliated candidates. And when we look at some of these issues, and certainly you brought it up yourself there with the old statement of principles, which is gone, right, and been removed in the last convocation, but issues around EDI as well as sort of the thought, right? I mean, kind of being the pillars on both sides, right, of where we should sort of position the Law Society, or where should the Law Society position itself in terms of what's the public interest, right? And I think you've carefully crafted sort of, well, look, I support these equity, diversity, inclusion initiatives, but at the same time, we don't want to return back to things like the statement of principles, right? So how do you kind of see yourself in terms of, if elected and you have the potential of these groups with again, these ideologies that are almost diametrically opposed to each other, how do you kind of control the temperature of convocation and find that appropriate balance, as you've pointed out.
Yeah, I think you hit the nail on the head, JP. Great question. And that's partly why I read Gary Joseph's email earlier today, right? Freedom of thought, promoting EDI. And I think what your audience and what the profession needs to understand, this isn't necessarily a binary decision, right? It's not either this or that. We can have both. There's no reason why we can't still be independent free thinkers without the law society dictating how we should or how we shouldn't do things. But we can also promote EDI in very constructive ways. And we do that first by looking in the mirror and looking, what is my particular firm doing to improve this? And we've got a track record. We've got live events. We've got recordings on how to set up DEI committees at your law firm. We celebrate women in law. We support Aboriginal charities and community groups. So there's lots of ways individual lawyers, small firms, and law firms can promote EDI. And that could be facilitated by the Law Society in a way that doesn't restrict somebody's freedom of thought, or that's going to have them subject to discipline if they don't sign certain documents. It's a tough racket running a law firm, especially if you're a sole practitioner or if you have a small practice. There's a lot you got to be concerned about, right? You have your overhead, you have payroll, you have taxes, you have professional development, you've got bookkeeping issues, you've got requirements in the Law Society. It's a tough game, but we're privileged, right? We're privileged in the sense that we get to serve. We get to serve clients who are usually at the worst times of their lives, right? Especially divorce lawyers, litigation lawyers, criminal lawyers especially, right? Somebody's going to lose their liberty. But divorce lawyers, think about it, JP. You're going through a divorce. Okay, I'm going to maybe lose my house. I might not see my kids regularly. I may have to start paying child support. I may have to start paying spousal support. I'm going to have to share my property. My identity is going to change, right? My friends, my family, my community, right? Like everything is getting turned upside down, but we get a chance to help these people through that process. And there's no reason why we can't use that skill set to come up and craft creative ways to improve EDI, to help small and solo practitioners run their businesses, and to make convocation a success and not a place of division.
Now, Russell, one of the other things kind of related to that, and certainly you've talked about it already, and I know it's in your page there in the voting guide, is about sort of creating more opportunities for Indigenous, Black, racialized lawyers, as well as other equity-seeking groups. Do you have any ideas in terms of maybe what the Law Society is doing, what they could be doing differently, what they could be doing more of to better sort of service this segment of the profession that you feel needs more support?
Well, benchers in the Law Society can show leadership, and not just to other lawyers, but to the province and the country on how we can really come up with the gold standard in terms of DEI and including everybody as part of our profession. Like I said at the beginning, I think diversity strengthens and enhances our profession. I think it makes us better rounded and a better community. So probably the strongest tool the Law Society has is its ability to educate, continually go development programs, start educating new lawyers, working with existing firms and larger organizations in terms of how DEI committees can work, what policies are effective, what's a good way to bring a more diverse community into your organization, whether it's a government or a private organization. So really, by showing leadership and by educating, I think is the essential function of our governing body. There's varying views on how that can be done. We do it daily in our firm, and I'm very proud of our team. And I think lots of people can learn from that.
Now, Russell, another you mentioned about is, access to justice. You're talking about collaborative approaches in family law. There's a lot of self-represented parties there. And last year, at the end of last year, there was the whole uh, FLSP, right, with that convocation in terms of creating another license for paralegals and others to potentially be able to enter into family law. Now, what are your thoughts? I mean, again, on what was sort of proposed? I know they're looking at maybe revisiting it a few years down the road, but from that perspective and being in family law, what are your thoughts and in terms of maybe addressing access to justice, and is this an effective way of addressing some of those concerns?
Family law service providers. Well, paralegals play a very important part of the profession. Let me just begin. Canada and the US have different language when it comes to paralegals. Usually we call them law clerks in a family law setting. I work with law clerks who probably know more than lawyers and who are probably better at doing what they do than lawyers are. That's how bright and talented these people are. But when we talk about the family law service provider and what they rolled out in terms of, okay, we're going to bring them in and help us do simple divorces, right? Some child support variations. And this is gonna be the fix to our overloaded court system. That's sort of a coy way of summarizing. It's much more deeper than that. But the cases or the content we're getting the service providers to help with, or what is designed to help with, are not the cases that are backing up our court system. If my income's changed and I need to change my child support, I think that could be done administratively at the Family Responsibility Office. We don't need lawyers or paralegals to get in that. The guidelines are there. You look at the chart, you change the number. So child support changes, motions to change, simple divorces, these are not backing up our court system. What's backing up our court system are contested issues, motions, custody, complicated division of property issues, equalization, pensions. So without trying to be sarcastic, I think the solution is more cosmetic than substantive, right? We're putting some makeup on it and hopefully, people will forget about the problem we're having with our court system for a while. This is not going to fix the backlog. The other concern I have, JP, is in 25 years, I've never seen a simple divorce. Right? There's no such thing. You need an experienced lawyer who does this work regularly to properly advise clients. They may not know they're entitled to share their husband's pension. They may not know what a survivor's pension is. They may not know what notional disposition costs are. Lots of lawyers don't know this. But we give somebody 12 weeks of training or a few months of training and say, okay, paralegal, go help these people. But they don't understand the deeper issues that could be underlying a simple divorce application. There's limitation periods, there's deadlines. If they miss a limitation period, they may not be able to recover those claims. So I think it's a bad idea the way they set it up for two reasons. Cosmetic, these cases aren't clogging the court system. Secondly, I don't think there's anything that exists that's a simple divorce. There's so many pitfalls when you're practicing family law, and there's so many things that can go wrong that what we may end up seeing I hope we don't. I hope I'm wrong, because if it works, it's great. But JP, we may end up seeing 12 or 18 months down the road, we're going to get lawyers saying we got to clean up on aisle 4, right? We've missed a limitation period, or I didn't know I was entitled to claim a pension. And now we've got to come in and fix whatever's been done, right? We set aside the whatever was filed, extend the limitation period, properly put the claim before the court, get a pension valuation. That's just one of many examples. So this simple divorce that the family law service provider was going to do and save the court some time and expense is now going to result probably in 18 months to 2 years of litigation, with us trying to reverse and correct whatever mistakes went wrong. So I think it's good. I love paralegals. I love law clerks. I think they play a very important role. in the profession. I have 12 law clerks who work at my firm. And like I said at the beginning, some of these people are much smarter than I am, and they know the job better than I do. So I think they play an important role. But the way this program was structured, under the guise that this is going to alleviate our court system and the strain on the system, I don't think it's going to play out that way. And I think it could have been done better and differently.
I guess then to follow up, Russell, in terms of, you've mentioned a few things already about collaboration and getting the government and other entities to sort of educate the public more about it. But what can the Law Society do? And again, if you're elected as a bencher, you'll be part of those conversations to perhaps better address that self-representation, access to justice, and even if it's just in family law, since we're talking about family law right now, differently than what they've done here with this FLSP?
Well, when we started, remote court hearings, presumptively remote court hearings, can make an immediate effect to improving access to justice and to help people who are self-represented. The Chief Justice can do that by way of a practice direction within a week. It currently is presumptively in person. During the pandemic, everything was remote. It had to be. So that one change, I think that one change alone is going to improve access to justice. It's going to make lawyers more efficient. It's going to stretch self-represented's legal bill. Perhaps they can have a lawyer for 3 or 4 hearings instead of just one and then running out of money. If benchers are elected and convocation says this is a priority, I think the Chief Justice and the Ministry of the Attorney General are going to have to listen, and they're going to have to reverse course. We don't want to lose this silver lining that we got during the pandemic, this technology and this efficiency to the system. We don't want to go back to paper-based court. We don't want to go back to in-person hearings. It's going to slow us down. It's going to take too much of our lawyers' time up, and it's going to cause people to go self-represented because they simply cannot afford having a lawyer there for each conference. The second thing we talked about, JP, was collaborative practice and mediation. The Law Society plays a really important function of educating the profession. So that could be CPD programs, like I mentioned earlier. It could be, having a discussion of how we can do this better. Could be also the Law Society can communicate and work with the Attorney General's office and explain how this is going to make the system more manageable. Right now, it looks like it's going to collapse because it's so overloaded. It's going to, if you think about what a self-represented person does to the justice system, right? They're not necessarily filling out their forms properly. They're not following the rules of the court. They're not filing their documents on time. Judges have to go out of their way to still be impartial, but to help them through the system. It's very hard on court administrative staff who are dealing with these people each day. And it's hard on the supporting duty counsel and the family law information centers. Everything's strained when we get more self-represented people going through the system. If we can keep them out of the system through mediation and collaborative practice and educating them, having the Ontario government run a Good Things Grow in Ontario program for collaborative practice and mediation, that will also have an immediate effect on improving access to justice. We don't need to have a committee study this for 18 months. The data is there already. We know that 84% of the people who enter into a collaborative practice agreement settle their case outside of the court system. That's a phenomenal statistic if you think about it. But the administration of justice is a bit of a juggernaut, and I think we can improve it. Benchers can improve it. They can direct policy at the Law Society. They can influence the stakeholders and decision makers at the Ontario Attorney General office. In addition, the government of Canada has a role to play in this. Divorce is subject to the Divorce Act, which is federal legislation. So the government of Canada can also help us improve collaborative practice and mediation. They made recent changes to the Divorce Act, indicating you need to explore other ways of resolving your dispute before going to court, and we can expand on that. So the legislation's in place. We just need to communicate it to the public and to the profession in a much better way.
Now, Russell, last couple questions here. Certainly, there are students, newly licensed paralegals and lawyers that are listening, and especially maybe some who are looking to get into family law. Any words of wisdom, any advice you have for them as they move through the profession?
You know, JP, our profession has a great tradition of mentorship. And my advice would be follow that tradition, find a mentor. If prior to the pandemic, I would say go to court, right? Sit in motions court, sit in family court, watch what's going on. You know, you can learn a lot in terms of advocacy, rules, how judges handle matters, just by sitting there and watching. Courts are starting to open up very slowly. So court dockets, when I've actually been requested to come back to court for the first time in 2 or 3 years, and I wasn't happy about it. But when I went there, you know, we had, I think, 5 matters on the docket. 1 was in person, which was mine, and the other 4 were remote. So it isn't quite the same experience today as it was prior to the pandemic, but that's always an option. Call up lawyers, right? Go through the directory and find, you know, whatever community you live in, whatever area law that you like. If it's, let's just say you live in the Central East region and you like family law, call me up, I'll help you. But, or whatever it is, just phone up some lawyers, say, can I shadow you for a couple of cases? Can I get some mentorship from you? I don't know of any lawyers who are going to say no, because they've all been mentored by somebody else. We do it formally through the articling process, but we also, you know, lots of people mirror successful people, right? We want to learn from people who are doing well. So phone them up, try to develop a relationship, see if you can shadow some cases, see if you can get some experience. That's what I did when I was in law school. I was second year, I wanted a summer job at a criminal law firm. I got a list of the certified specialists. The O.J. Simpson trial was going on, so I had that going on in the background. And I just called up people until I got a job. After a day and a half of calling people, I landed a job with Michael Caroline, who just recently passed last year. Great criminal lawyer, fantastic advocate, real professional, real gentleman. And he took me to trials. He took me into pre-trial discussions. We did client interviews. Eventually, he'd send me to court. But just a great learning experience from somebody that's already doing it. So I would look for a mentor of some sort and shadow them. If you can't find one, see what courts are having in-person hearings. Go watch those courts. Some of the courts have Zoom hearings. I know the Court of Appeal recently did a Zoom appeal on the issue of the tort of domestic violence. So you can watch that online. So there's lots of options out there in terms of trying to get that exposure.
Perfect. So Russell, last question here, and thanks once again for taking the time to speak with us.
It's been a lot of fun today. Thank you, JP.
Last question is essentially for all the lawyers that are still listening and have up to 40 votes in the upcoming election, why should they cast a vote for you?
Well, you don't have to necessarily count me. What I would ask you to do is look at the issues and try to find a venture candidate that resonates with you, that shares your experiences, that is going to advocate for whatever you think is important to you, and that's going to help you in the profession. Ultimately, ventures they need to get elected by voters, and voters are lawyers. Only lawyers can vote for ventures. Well, paralegals can vote for the paralegal candidates, but my advice is look for somebody that resonates with you, that shares your experience, that you think is going to be a good advocate for whatever you're advocating. I've got 25 years of experience. I'm telling our audience today, I'm going to be independent. I'm going to exercise my common sense and good judgment. I'm going to expect the other benchers who are elected to show some decorum and civility because we're representing the profession. And I'm going to use my good judgment when making decisions. I'm not going to be at the behest of any particular group or interest group or whoever brought me to the dance. I'm going to have my decisions informed by my core values. And these values have helped me grow my firm to be successful and diverse. Respect, teamwork, service, and leadership. So that's what I'm going to bring to convocation. If you want to elect me as your bencher, I'm going to do the very best I can. I would certainly appreciate your vote, and I'm asking for your vote. But choose somebody that reflects your values and that you think will do a good job for you.
Perfect. So once again, thanks so much, Russell, and thanks for everyone for tuning in.
Thanks, JP. Have a great day. And once again, I want to express my gratitude to you for having me on, and certainly our gratitude to the audience for listening in today.